Put your hand down. Tell me your name, sir.
Tyrone Vera.
And Mr. Vera, you're the father of Daniel Vera?
Yes, sir.
Okay, and let me ask you, does your son live with you?
Yes, sir.
Okay, and is he working?
Yes.
What type of work does he do?
He's a agent recruiter for it's a relocated company.
Okay. It doesn't appear that he's ever been in trouble before, has he, that you know about?
No, never the
No?
job. No.
Did he grow up here in Broward County?
Yes.
Okay. What I'll do is I'm going to release him today. No bond is required, but I'm going to order that he doesn't drink any more alcohol. You can tell him this. I'm going to put it on the order. No more alcohol for him. And the other thing is I'm going to I'm going to order that he goes to pretrial release. Can
I wasn't
give the
sure.
father
I
a map?
checked. I did a quick Google search. Depending on how
Father
much
a map?
data, like how much shit,
Yeah.
like 64, that's what they sell them for.
Let me ask you this. Is it possible you could call over there and have him brought down to the main courtroom over here? Okay.
I'm not exactly sure where he's located right now.
Could you find him for me? And whoever you find, tell him to have him sent to the main courtroom in the jail. Sir, you can have a seat. We'll take care of it in a moment, all right?
Thank you very much.
Ma'am, you want his paperwork? Oh, you got the, okay, there you go. That's the paperwork we're gonna use to, okay. So we're good, okay. Good afternoon, everyone. My name is John Hurley. I'm your judge this afternoon. You're not here for us to determine whether you're guilty or not. It's not for today. You don't need to tell us about your case. You don't need to explain yourself, defend yourself, or make any excuses. Not for today. Save that for your attorney in a private meeting. Understand you have the constitutional right to remain silent. You're not required or expected to say anything today, but if you give up the right to remain silent, you begin to speak about your case, whatever you say can and will be used against you. Everything today is being recorded. Also, if you have a private attorney, let me know who that is. We'll contact your attorney and let them know that you're in court. Now, may I see John Wilborg? John Wilborg.
Judge, that's Wyborg.
Is it Wyborg? I'm sorry. It's
Main jail. You're hiring private, right?
Wyborg. All right, Mr. Wyborg, let me just remind you, you shouldn't say anything about your case. You have a very fine attorney, Mr. Dutko, representing you today. He's in the courtroom with me. Good afternoon, Mr. Dutko.
Good afternoon, Your Honor.
So your client's been charged with aggravated battery with a deadly weapon. He's been charged with 2 counts of culpable negligence, and count 4 is a probation violation. Now, do you have any comment about probable cause?
Let me ask this question.
Okay.
I have count 1 from the clerk's printout as aggravated assault.
Okay, let me look here. You're right, aggravated assault. You're right.
Judge, as to the allegation of aggravated assault, there was a driving incident that's set forth in the probable cause affidavit, but I don't know that rises to the level of an aggravated assault. But that's not my greatest concern.
Okay.
My greater concern, we can deal with that in time. There's a
Right.
bond on that amount. My greater concern is he apparently is still here in the jail because he's on probation.
Right.
That matter is before Judge Sentinel, although it's in the state of probation. Here's what I want the court to be aware of. This incident went before you today. He was just arrested. The incident actually happened, or was reported to police on January 18th of 2015. In the probable cause affidavit, it mentions two names of victims, Alex Zuccarelli and Elisa Fowler. Alex Zuccarelli is Mr. Wyborg's girlfriend. They have a current relationship. This whole thing sort of stemmed from an argument, boyfriend-girlfriend argument. Elisa Fowler, at one point, was Zuccarelli's best friend. She's presented this case and she's pursued it. There's been a lot of communication over the last couple months about this. Bottom line, though, is that Zuccarelli and Wyborg are both scheduled for graduation this weekend from FAU. And if there's any way that the court can see to release him with conditions on the VOP, so that he can attend that graduation. Most appreciated. That's what his mother is called when I talked to him.
Okay. Have you had contact with the alleged victim in this case?
I have not.
Okay.
But I will tell you that there's been extensive contact with Ziccarelli, and she's given us information about the victim's position. And the victim has now embarked on whether it's Facebook or some social media, putting this arrest on. And I mean, if the question to me was going to be, what's her position today? She's not a friend of mine, as far as the defense is concerned.
Okay. State what's your position?
Your Honor, it's pretty straightforward. I believe there is probable cause for counts 1 through 3. These are, and it's based on more than just a probable cause affidavit. These are filed charges. As the court is aware, the state cannot, by law, file a felony information based solely on a probable cause affidavit. Their sworn statements have been taken, so I believe there is probable cause.
Well,
on 1 through 3.
I do agree. Go
I'm
ahead.
not really contesting
No, we're not
that.
arguing probable cause.
That's the issue.
What is it?
Because if there's probable cause for aggravated assault with deadly weapon, that is an enumerated offense under 4806. And Judge Singal is the only one that can order his release at this point in time after having a hearing under the statute.
Mr. Dutko, here's the issue.
I'm not prepared to address that. I don't know the answer, but I presume
Here's
he
the
knows
issue,
what
and it
he's
comes up frequently. You know, the anti-murder statute. If someone either is on probation for a dangerous crime, they have a dangerous crime in their past, or the other way to formulate it is if they're currently charged with a dangerous crime and they're on probation even for a non-dangerous crime, anti-murder statute, I believe, I haven't read it in a while, says there has to be a danger hearing. So I don't know if that danger hearing can be waived.
My interpretation pursuant to statute is that the hearing has to be held, and the only judge that can have that hearing is either the chief judge or the judge that put him on probation, or whatever judge is in that division if they've rotated.
In essence, it's not a matter that can be addressed.
It's
before this
non-discretionary.
court today.
Right.
Judge, if that's the law, I
my
wasn't
hands
prepared
are
to
tied.
address that. I didn't see the paperwork until 5 minutes ago.
Right, I understand.
And I didn't know about this hearing until an hour ago.
I understand.
so.
Oh, I know. I'm sorry we caught you off guard here, but I wanted you to try to get over here. By the way, sir, I gave your attorney very short notice to be here, so what do you,
I think the remedy is I need to go back to the office and get a call into Judge Singal to see if there's a possibility we can get before him.
okay.
Get before him as soon as possible.
Yeah. Okay. Can I see the attorneys up here real quick? Can I see up here? Sir, your attorney's working on it, so I'm going to order count 1, your bonds 5,000, 2 and 3 are 100. Count 4, you're going to be held on a violation of probation, and I'm going to order that you have no contact with Alyssa Fowler and no contact directly with Alex Ziccarelli. Okay. Okay, so I'll scratch that, but no contact with Alyssa Fowler, directly and indirectly.
Thank you, Your Honor.
Okay, now we've got Mr.
Okay, only reason is
Yours,
because I don't want to pull the.
Thank you, sir.
Thank you, Your Honor.
Okay, What can I do for you, Mr.?
Mr. Graham was reset for yesterday for perfection. Dairy Nick Graham. Mr. Linder did provide me with a narrative that I'm
Get
sure he's
Mr.
going to
Graham
hold
up.
on.
Yeah, it's perfect for you.
Conti, Your Honor.
Okay, let me find him. Hold on, give me just a moment.
There he is.
Paperwork here.
Lisa
Okay.
will have his case he's
Now-
on probation for the third. Sarah will have the.
Okay,
case
so
the second.
count 1 is burglary of a conveyance, 2 grand theft. He's on probation, I think, on count 3, correct? Now, I've got the supplemental. I highlighted it. It says reached inside, grabbed his cell phone from the front passenger seat without permission, fled. So it seems that speaks for itself. Do you have anything you'd like to say on behalf of probable cause this time?
That's sworn. I read it, but it's sworn, stamped.
Yep, sworn, notarized.
Signatures on the left, Your Honor. The notary's on the right.
So,
That's not one of the officers who's been arrested recently, right?
I'm not going to make any comment on that.
Darren Nick, we tried, so I'll see you next week with your judge again. Judge Hurley was kind enough to set this to address the deficiencies in the probable cause affidavit. They've, in my opinion, as well as the courts, they've fixed that for purposes of probable cause, which means they're going to hold you. And like I told you yesterday, Judge Hurley, even if he wanted to, could not release you on the felony because that's not his warrant. So I'll see you next week in court, okay?
All right.
Thank you.
Thank you.
Yeah.
Okay, Mr. How you doing?
Good afternoon, Judge. Salam Zanganan and Brian Sibler on behalf of Jay Joseph.
Okay, may I see Jay Joseph, please?
Good afternoon, Judge.
Jay Joseph, come on forward. Good afternoon. You just
Page 14.
I've got it. Okay, so okay, sir, you're being represented by 2 attorneys here in court. You don't need to make any comment about your arrest. Please allow your attorneys to speak on your behalf. Do you understand that, Mr. Joseph? Okay, now, both the attorneys, the defendant's been charged with racketeering, count 1, unlicensed money services, more than 100,000, count 2, fraud regarding use of someone else's identification without their consent, more than $5,000 in the fraud. Court finds probable cause, well, unless you have an argument about probable
Judge,
cause.
it appears that there's a warrant. It appears that another judge has already found probable cause, so I'll defer to that previous
Okay.
ruling with
Now,
regards to probable
Was there a,
cause.
there's a warrant? Okay, there's no nebbia on this, is that
No,
right?
there are, Your Honor. There's an order setting bond with
Oh, I do.
special conditions.
I see a nebbia signed by, I'm not sure who the
This is
judge
Judge
is.
Porth, I believe.
Judge Porth signed a nebbia, order setting bond, 250 on, 250,000 on count 1, 200,000, 350,000.
Currently total $600,000.
Okay,
Correct, Judge. And I will say, with regards to the requirement for proof of funds, I think that that's normal in these types of economic
Right.
crimes. I think the term nebbia is strictly used in the federal system. I believe and this is something that I was just educated on. I believe the appropriate term is proof of funds, because if there is a motion for a nebbia, I just dealt with the same specific issue, Your Honor, in Miami. But we agreed that this is the type of allegation that is a common application.
well, I think of the federal system, and I did do federal work as a private attorney. I think the nebbia requirement is to prove, it has to be a proof of a clean, legitimate source of the funds. But
Correct.
then you add on non-nebbia things, which are like full collateralization, no encumbering the collateral while it's being used as collateral, things like that, which are not necessarily nebbia, they're addition to nebbia, right?
Right, they're part and parcel. They're associated with the same. So
Right.
I think that we're all in
Yeah,
agreement that
I'm sorry.
we would have to prove that the funds came from a legitimate source, and it
No
would have to be
objection to the
collateral.
nebbia.
No objection. Judge.
Okay, so
Your Honor, just so to be clear on the record, reviewing this, it appears that the bond at this point is set at 400,000.
Is it?
250,000
it's
on count one,
400,000.
100 on count two,
This is why I went to
50.
law school.
Would
Judge.
you like it
Couldn't
at
add.
600,000, Mr.
I had to double check. It's okay.
400 is still a chunk of dough, Judge.
I agree.
Our real issue is that very high dollar amount.
Right.
And we're asking the court to reduce the bond. Let me give you a couple of things that you should consider. Number one, there are co-defendants. Their bonds were reduced respectively to $80,000, and I think it's
150 for the other.
150. We're asking the court to reduce it to $80,000 plus the same special conditions such as the nebula and the collaborations and all that stuff. Here's our issue. Number one, bond is currently tantamount to no bond at all. Our client is a laborer in a construction firm. He's gainfully employed 40 hours a week. He has no prior criminal record. He has very extensive ties to this community. He's lived here in excess of 10 years. He probably has at least maybe more than half a dozen family members who are local. In fact, his sister is here today, and hopefully when he is released from custody, if you reduce the bond, he will be released. He is a lawful resident in the United States, and I think there's ample grounds for this court to consider that it is not a flight risk. This is not a sexually motivated offense. It's not a violent offense. There's no issue of concern, things of that nature. And right now, we just need a bond that he can afford to post, and that will also guarantee.
Well, let me ask you this. Are you asking that the bond be reduced and Nebia be set aside, that you don't have, or are you just saying,
Just the dollar figure reduced, the same other terms and conditions.
Correct.
well, do all the other co-defendants, they were all equally involved, or is this defendant more
Well,
culpable in
here's the
your
thing,
opinion?
Judge, and frankly, I don't. All I know is what's in the affidavit before you, and I would note that the investigator and the detective made a point of noting that there are additional facts that they didn't include in the report because the purpose of their affidavit was solely to satisfy probable cause. I would note, Your Honor, that, and I think it's relevant, the bond modifications on both co-defendants were done by their assigned judges.
Right.
And their bonds were kept the same at their first appearance. Their attorneys filed thorough motions, and I don't know, frankly, I don't know what testimony was taken at the bond hearings. And all the special conditions were kept on both of them. My request, Your Honor, is going to be that the bond is kept at 400,000, so that the assigned judge can he can only be released if Your Honor sets the nebia. He can only be released upon that judge's.
What I think Mr. Silver is requesting is not to touch Nebia, just lower the bonds so they can work on the bonds before you get to Nebia.
No, I understand, but that's the thing. If you're going to be working, what he can post is what he can post, and if you're working on the paperwork for Nebia, that's not going to change. What the
Well, it does change, because now you have to worry about the collateralization issue, and it's a different collateralization
But where it
issue
but
if you got 400,000 versus 80,000.
Okay.
I'm not saying I'd put it at 80, but
what I'm saying is the property he has is the property he has. That's not, it is what it is, and the sources used to post the funds, those are what they are. It's not if there's if you keep it at 400,000. And he only has collateral to satisfy 200,000, and the sources used, for the 20,000. If that's what it is, then that's what it is, and that's all they can show to the state, anyways. And then they can ask the court to reduce it to 200,000, because that's what he can afford to pay.
okay, I know what you're saying, but this defendant is the third one in line, correct?
Correct.
The other two have been arrested?
Yes, Judge.
Or at least two other ones have been arrested. He's the third one. So we have the benefit now of seeing what the other bonds were reduced to on the other people, and I think,
Well, we have the benefit of knowing without knowing why.
okay, now, this man has no criminal record.
No
right?
criminal record.
Okay, and you're telling me that the other people were reduced to 80,000 by their judge after Nebia hearing?
Well, see, that's the thing.
One was 150.
Okay, so now, do you know why one was 80
Judge,
and one was 150?
What I think, judges, I read the probable cause affidavit that the court allowed us to review, and if you look at it, what it states is that our client's involvement, the allegation is that he had that this was a scheme where they were doing illegal tax, and he was pretty much at the tail end, the person cashing the checks without a license. So I believe he's the least culpable
I don't
person.
know, he's the one, going to
mean-
the bank putting the dough in his pocket, right?
Well, I mean, it's the last step. If you look at these tax fraud
He's
allegations,
certainly
There's-
not the ringleader in this.
But
I'll tell you
they're
that.
saying
Ringleader, but he's the one who's
He's the
they're-
low end on the totem pole.
they're saying cashing some
loading up
checks
the truck at the bank.
and cashing over.
Allegedly.
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 There's also saying cashing some checks and cashing over
And
$450,000.
We're not asking for a $5,000 bond here,
I know.
Judge. We're just saying, make it a substantial bond, but one that's appropriate for this particular offender and his circumstances.
He allegedly
400,000
cashed
might as
over
well be-
$400,000 worth of
Might as well be
cash,
400 million.
and we don't know where the cash went. Is that
But
fair
see-
to say? Has it been recovered?
Your Honor, I don't know. All I know is what's here. That's all. I believe that's all any of us.
We're asking that he get the
and-
same low bond as.
and I will say this, Judge, if the funds were put in any kind of bank account that has any kind of collateral connection to our client, I'm sure the funds have been frozen, or that, you know, the law enforcement have done their due diligence in this case.
Okay. Court will, I'm going to reduce the bonds. I'm going to keep the Nebbia and
Well, we'd ask that all the special conditions. Be
all
kept in place
special
here.
conditions
All right.
remain. Court's going to set count 1 at 80,000, count 2 at 10,000, and count 3 at 10,000. Its total bond's $100,000 today. All Nebbia requirements, off the special conditions of bond remain. All right?
Thank you, Judge.
Thank you, Judge.
Thank you, State.
Okay.
That's it,
Now,
Straight up the middle,
okay.
up the middle, up the middle.
Tell me when
Go outside,
Mr. Vera gets to
Avery? Is it Avery?
Okay.
What was the name of the person he called for?
Well, that's fine. I like your handwriting. Okay. Now, ma'am, which case are you here on? Gregory what? Lynn, come on up right here. Gregory Lynn?
Were you here,
Just
Gregory?
one first time.
Come on up.
Gregory Lynn, come
President
on
the
up.
main judge.
Aggravated assault with a deadly weapon, aggravated battery.
It's on page 2 of the docket.
Okay. Gregory Lynn, you've been charged with aggravated assault and aggravated battery. The court finds probable cause stated their priors.
One moment, Your Honor.
Ma'am, raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
So go ahead.
Okay, tell me your name.
Alyssa Straight.
Speak up for me.
I'm sorry. All right. Alyssa Straight. Alyssa Straight.
Straight, okay. And ma'am, are you feeling okay today?
I haven't had any sleep, and this has been a little traumatic for me. So.
I understand. Okay, well, we're not gonna get you upset. Let me just ask you, ma'am. You're the girlfriend of Gregory Lynn?
Yeah.
How long have you been the girlfriend?
We've been together romantically for about 8-9 months, but I've known him since I was 14, so there's a lot of
So
history.
there's no children together, right?
No. I mean, actually, I will say
Well,
this.
there's-
I
is
just
it
went to the
on hold?
OBGYN that day to see if I was pregnant. And get my blood work taken. So I don't know. I don't know if I'm pregnant or not.
Okay, now, what does he do for work?
He does computer work. He works, I don't remember the name of it. It's a new location.
Does he own any land or property down here in South Florida that you know about? Buildings or
No,
apartments?
we're renting at the moment. Their lease is up in about a week.
Okay. And do you know how long he's lived here in South Florida?
I think most of it is his life.
Okay.
Oh, no. He lived in Pennsylvania, but most of his life, correct.
Okay, and ma'am, before this incident, have there been any other incidents of violence in the relationship?
We've had arguments, but not to this
Has there been any
extent.
time where he's physically harmed you in the past?
With physical marks? No. There,
Forget the marks. Has he ever been physically abusive to you?
no.
Okay. Has he ever threatened to harm you?
No.
Okay, I just need to ask these questions.
Yeah.
Does he ever carry any guns or weapons with him?
No.
Do you think if he's released from custody, he represents a danger to you or anyone in your family?
God forbid, no.
No? Okay. Are there any drug or alcohol issues involved in this?
In this instance, there was.
What is it, alcohol or drugs?
He had a 6-pack of beer, and we had 2, oh my God, my earrings.
Had you been drinking also?
Yes, we both had been drinking, and
But were you
he
impaired?
had a 6-pack of,
Let me ask a question. I read this, and it appears that it was, it looked like, I mean, for lack of a better term, it looked like it was a both people were, I'm not going to use the term I thought, but
Intoxicated?
what?
Intoxicated?
It looked like a brawl.
It did.
It looked like two people had been drinking and they got into a brawl.
Correct. It escalated to the point at which it should not have ever escalated.
He whacked you, you whacked him, you broke the bottles on the floor, he picked them up, and it was going back and forth.
It was, I would call it a mutual combat thing.
You
I mean,
know,
I may be
you-
a bit deep,
it
but-
says you were smashing beer bottles all over the floor.
Mashing beer bottles? No, actually, that would be a dual thing.
Both of you were smashing beer bottles.
Clearly, because I
Were you injured?
I saw another one in the bathroom that I did not smash.
Were you injured, ma'am? You said you have some small cuts. Where are they? No, okay. Could you step over here?
Is that all you saw?
Come up right here.
Kifu.
Ma'am, could you?
Is that all you
ma'am,
saw?
Excuse me. Could you stand up right here with me? Right here. Stand right there. Okay, ma'am, just move your top, but not too much. Okay, go ahead. You can move it a little bit more. Okay, just hold it there for a second. Okay. How did you get those scratches? No, how did you get those scratches?
He was arrested in December. He was arrested in December.
You have bloody scratches like a cat scratched you all over your chest. Let me see your arm. Okay, I don't really. Do you have anything on your back? No? All right. You can head back over there. Thank you.
Carl.
Thanks.
Carl.
Just give me a moment real quick. Now, okay, Greg Lynn, let me ask, does he have any criminal record state?
Your Honor, he was arrested early December last year for domestic violence battery against Ms. Strite.
Dismissed.
And
Against who? Ma'am, please.
it was dropped.
Against who? The same person?
Yes,
Okay.
Judge. The allegations were, one moment, Your Honor. There was, Ms. Strite was dealing with some health issues. They got into a verbal argument. Mr. Lynn grabbed her. She was able to free herself, struck him in the face in self-defense, attempted to leave the area. He then grabbed her body, forced her on top of a couch, placed one hand on the side of her throat, and placed his knee across her windpipe. Stated that she retaliated by randomly kicking and swinging her hands at him. In the process, she struck him about the face and chest and was able to escape. She exited the apartment. Disturbance continued outside. Unknown person dialed 911. States that Ms. Strite did appear to have redness and minor swelling about her throat and face.
May I say something? That was from Mace, not from us.
Anything else?
That's all.
Okay, ma'am. How, that case was dropped?
Dismissed immediately.
Why? Do you know?
Because it was dim lit, it was at night, and
Well, let me ask you, did you go fill out papers or something to say you wanted the charges dropped?
no, actually, I didn't have to do much at all. It only took like maybe a couple of weeks to.
What did you do? What did you do? Did you take any steps to get it dropped? Did you fill out papers? Did you talk to
Yeah,
someone?
I called an attorney immediately because
Okay, but you got the case dropped. You asked to have it dropped, right?
I did a statement letter and I asked to have
Okay,
it dropped.
why
correct.
did you want those charges dropped?
This is the reason why.
Why?
Because there was false documentation. The witnesses at which called the police said there was a gun involved. There was no gun. It was a phone.
Got it. Okay,
Something that
I understand.
kind of surprised
Mr. Miller, is there anything you want to add today?
Judge, 28-year resident of South Florida. He's been at his current address for a year and 5 months. He does take care, supports 3 children from another relationship. They're currently with their mom. It's a 4-year-old and a pair of 2-year-olds. He has strong family ties to South Florida. He does have a place to stay separate from the alleged victim while this case is pending. He does have some money in the bank, and he's hoping that his family will help to bond him
Sir,
out.
the court's going to set your bond on count 1 at $7,500, count 2 ROR. The court realizes there was some mutual combat here, but the court also notes the second time you've been arrested in a short amount of time for allegedly abusing the same person. The court also notes, sir, that the level of injury to the alleged victim. I mean, she came up here. We had a witness. I mean, she was really sliced up. Her chest area has bloody slices on it. It's concerning, the level of violence. So I'm going to order you have no
Judge,
contact.
we need a photo
Oh,
order.
wait, no, may I say something, please?
Just
I
give me a
did it,
moment.
Dale.
The court's going to order no contact with Alyssa Street directly or indirectly. Don't call her, text her, email her. Stay 500 feet from her at all times. That's where she lives, works, goes to school, anywhere in between. You're not allowed to possess any guns, any weapons, any firearms while you're out on release. And you're not allowed to consume any alcoholic beverages either, sir, while you're out. Thank you.
Judge, may I please,
luck,
may I please
Mr.
say
Lynn.
something?
What would you like to say?
Actually, I spoke with you. I do want contact because I know he's not a threat. This
Yes.
is because there was so much intense, a high amount of alcohol that
Right.
might have, ignited this. This would not have ever have happened. I've not ever felt any threats, nor do I feel threat. I want contact with him because there's no threat. I've known him for over 30 years.
Yes, ma'am. Okay. Well, I appreciate your input, and I definitely consider your input. However, the bond will remain where it is. The conditions of him not contacting you will remain. I thank you for coming to court. I'm sorry we had to meet like this. All right, ma'am?
There's nothing I can say or do or show you that, or state that he's not a threat.
Not today, ma'am. Not today. The court's
So-
made its decision. The court's going to stay by its decision, but I
Okay,
do
so-
appreciate you coming in. I appreciate your input. And, but, ma'am, I sometimes make decisions that people don't agree with, but in this
I don't agree. I understand where you're
In
coming
this
from.
case, I'm rather confident I've made the right decision. All right?
I know otherwise, because I know him.
Yes, ma'am.
The only thing is, let me ask you now, from this point on, because this is foreign to me. What happens from this point on? Like, does he go to bail bondsman?
He can try to bond out any way he pleases, ma'am. He could go to a bail bondsman. He could have a family member do it.
I have his what do you call his wallet.
You may want to give that to his family and let his family give that to him. All right?
I don't have his family's number.
Well, ma'am, you may want to drop it off somewhere. You know what I mean? That's all I can tell you. Thank you, ma'am. Good luck.
No.
Thank you.
Judge, the deputies are asking if you could please call Calvin Tipton. He's the last person on the docket.
Can I see
Page
Calvin
15.
Tipton?
Come on, Calvin. Come on.
I
Tell
thought
me
you
when
said-
we have Vera. Is he? Okay, I'm going to call him next. Okay. Mr. Calvin Tipton, Grand Theft Auto. Court finds there is
He already found problems.
Go ahead.
Previously. I think you already found it previously.
Yeah.
Judge, Mr. Tipton has declined the services of the
Why
public
are we
defender's
back here?
office.
Does anybody
He
know?
finally got back from on loan.
Oh,
Right.
okay, Mr. Tipton, I find probable cause for Grand Theft Auto. I think I've already found probable cause in the past, but State, let me ask you, does this gentleman have a criminal record?
Well, the only thing I see as far as Broward goes, and I'm guessing there's other priors based on his sentence, attempted purchase of cocaine, he was sentenced to 62 months in state prison.
Okay, sir, how long have you lived down here in South Florida?
Yeah, my last charge. I've lived here like 3 years.
Do you have
now.
any money in the bank?
No.
Sir, based on the facts of the case, your criminal record, your bond's $1,000. Thank you. May I see Mr. Vera,
Okay.
please? Vera. Daniel Vera, come on up, sir.
This is Mr. Vera, Judge.
Mr. Vera, sir, we
Oh,
have
he
your
has to
parents
wait.
in the courtroom. You're charged with DUI, enhanced breath reading. Sir, the court is going to release you on your own recognizance today on all counts. I'm going to require you get a pretrial release tomorrow between 8 and noon. You're going to be drug tested. You're going to be tested for alcohol. You're not allowed to consume any alcoholic beverages while you're on release. Do you understand, Mr. Vera?
Yes, sir.
Sir, you only have 10 days to get a temporary driving permit. Do you understand that?
Yes, sir.
Okay. Thank you, sir. Yep.
All right, good luck.
Sure. Yes, yes.
And the testing, how often would that be? Is that weekly?
Once every couple of weeks. It's
Once,
fine.
okay, bi-weekly?
Yeah. Okay, come on up, Mr. Vera. I've written you some notes here. This is what your son's supposed to do. He has 10 days to get a temporary driving license, no alcohol, and tomorrow he has to be a pretrial release, okay? So there you go. All right, take care, sir. Okay. Okay, thank you very much, the Vera family. Have a nice day. Okay, we have Miss, is that Miss Morjan in the back?
Yes, it is. Hi.
How are you, ma'am?
Good, how are you?
Good to see you again.
See you.
All right, so, may I see Christopher, no, put that to the side.
Chris was going nuts.
How about Stefan DeGurdon?
Mr. President, the main judge, he is declining the services of the public defender.
Okay, sir, domestic battery, the court finds probable cause. Are there any priors on this gentleman?
No priors, Ron?
Sir, you, are there any, no priors? Sir, how long have you lived down here in South Florida?
About 13 years, sir.
What kind of work do you do, sir?
Law enforcement officer.
Okay. And do you own your own house? Do you own your own property?
Yes, sir.
Okay,
Yes, sir. I have a 1.5-year-old son.
I understand that.
Military.
Your Honor, I am showing, it looks like a battery in 2010 out of Broward.
Really? It was an arrest, though. But
No, I'm showing he got withholds on 2 counts.
Really? Sir, are you being represented by an attorney right now?
Yes.
Who's your attorney?
Yeah, it's not this guy.
Don't go down there.
I'm not sure. It could be either Connie Kaplan or Don Oswald.
And is that through your FOP or PBA?
No, it's going to be private, I believe.
Okay, well, tell me the name of the people. I'm going to give them a call. Who is it?
There's Connie Kaplan or Don Oswald.
Don, how do you spell Don's?
Oswald?
Oswald, O-S-W-A-L-D?
I believe so, yes.
Connie Kaplan or Don Oswald?
And just so you know, Judge, yes, I checked in Odyssey. One moment, Your Honor.
Go in now.
I'm showing, 2011. He was put on probation, anger management. Probation ended up being terminated.
Okay. What's the, sir, did you serve in the military?
No, sir.
Okay. What, do you have any contact information for either of the attorneys, Don Oswald, or do they work together?
No, they used to, but not anymore.
Connie Kaplan or Don Oswald? Are you FOP or PBA, sir?
FOP?
The number I have for Oswald is,
Hold on one moment. I'll be right back. Sir, have a seat. Could you have a seat? We'll be back with you. Thank you.
Thanks, Judge.
I gotta talk to her.
Okay, may I see Dwayne Mackey?
North Broward, Judge.
Mackey's North Broward.
Mr. Mackey, domestic battery, the court finds probable cause.
Will the court sign photo orders, Judge?
Yes, I will. Do we have any priors on Mr. Mackey?
One moment, Judge.
Allegedly,
Hey, Monique Woodley, MW3, get her ready.
well, the defendant claims he makes it $5,000 to $10,000. I don't know what time frame that is, but. Sir, how long do you have any money in the bank?
Sir, I don't make. I go to school, so I don't make that much. I go to school. I don't have any money in the bank. I pay. I use all my money to pay my rent.
Do you? Who's going to help bond you out of jail today?
I don't have anybody help me bond me out of jail. I'm missing school right now. I have a major healthcare administration major. Work as intern, paid intern at Joe DiMaggio in the psych ward. Right now, I'm missing that as well. That's my sole income right now.
Okay, thank you.
Thank you.
I have concerns because I'm looking at his booking photo and the way he appears right now.
Okay, what is your concern?
He may have been beat up when he came here. I don't know. I don't know how he got those injuries.
I do see a mark over his right eye. And it looks that way in his booking photo, but I could be wrong. You made him order photos?
Yeah, I'm ordering photos.
You may want a nurse to be present for that also.
This was sir, excuse me if I may speak.
You know, you really shouldn't speak. Let me state, are there priors on him?
He's got a warrant out of South Carolina right now for damaging property. And that was the warrant was issued February of last year. Additional priors include out of South Carolina, unlawful carrying of a weapon, injury to property, criminal conspiracy. That was from 2012.
Excuse me, sir.
No, hold on, sir. Wait till we're done. We'll talk to you in a moment. Go ahead.
2 counts of burglary in the second degree. That's from 2010.
Sir, the court today is based on the level of violence. The court's concerned for the safety of your brother, Damien. You allegedly got mad at him because allegedly he snitched on you. And
no, it's not on that.
The court's going to set your bond, and noting you have a out of South Carolina.
Excuse me, sir, if I may.
Your bond today is $5,000. You can bond out. Do not have contact with Damian Garvin. No contact directly or indirectly. Stay 500 feet from him at all times. Thank you.
Judge, I'm sorry. I asked the court to reconsider under the circumstance. I believe the court's misread this probable cause affidavit. It would appear that Mr. Mackey was complaining that his brother snitched on him to get him arrested in this incident. It doesn't sound like he's saying that was a motive for a fight. It sounds like he's upset that his brother ratted him out to the police about this incident.
Yes, I understand that. That's the way I took it. Thank you.
Well, I'm just wondering if the court could reconsider that bond. It seems a little high for a fight between siblings.
No, the court's going to leave it the way it is. Thank you, though. All right, may I see, okay, we're going to put that to the side. Now,
Singletary?
Did you call the city?
I don't think, I think Andrew said earlier on.
Talk to the
I didn't tell you anything.
No, I understand. Okay, you want to see what I have up here?
I don't know how.
What's the number? Is that Drew? Is that Drew?
It is.
Okay, Joe, is that Joe Singletary right there?
It is, Judge.
Domestic battery, sir. The court finds probable cause. Do we have any priors on Mr. Singletary?
One moment, Judge.
Mr. Offsall, we need a photo order with a nurse for Mr.
Ma'am, was there any-
Singletary, please.
Mr. Singletary?
Yeah.
You need a photo order?
Yes,
Steve,
please.
let me ask you, ma'am, was there any contact with the alleged?
Resisting without violence, 2010. Trespass, 04. Possession of marijuana with intent to sell and resisting without violence, 2000.
So I'm going to set your bond at $1,000. It's a minimal bond, but I'm going to order you have no contact with Sabrina Edmond for the time being directly. You can go through a third party. You have children with her. Go through your family, have contact with her. But other than that, stay 500 feet from her at all times. You're not allowed to possess any guns or weapons, all right? Thank you.
Yeah. Thank you, Judge.
Yeah.
Off the middle, sir. Outside.
All right, Steve Dickey, sir, you're charged with a domestic violence, battery, and tampering with evidence. Court finds probable cause. State, do you have any priors on Mr. Dickey?
Yes, Your Honor. Priors include last year, trespass, criminal mischief, and a charge of assault was declined. 2011, 2 counts of attempted burglary of a conveyance, 24-month state prison as a habitual offender. 2001, burglary of a structure, 10-year state prison, habitual offender. 97, burg dwelling, grand theft with a VOP, just over 94.5 months state prison. 97, burg conveyance and grand theft, VOP, same sentence. 97, burg conveyance, VOP, same sentence. 97, burg dwelling, grand theft, same sentence. An attempted burg dwelling, 97, same sentence. Burg dwelling, 97, same sentence. 97, grand theft, 5 years state prison. 95, burg dwelling and theft, 94 months state prison. 2 more burg conveyances, 95, 1 with a grand theft, 1 with a petty theft. Burg dwelling, grand theft, 95. Loitering and prowling, 94. Disorderly conduct, 92.
Okay. Mr. Dickey, anything you want to say on behalf of this defendant, sir?
Judge, Mr. Dickey has been living in South Florida for 25 years. He's been at the same address at his current address for about a month. He works in tree service, been doing that for about a year. He does have strong ties to the community. He has lots of friends down here, apparently. No money in the bank, no real estate. Does have a place to stay separate from the alleged victim, and he's hoping that his friends will help to bond him out.
Okay. Now, ma'am, I'm going to give you with the monitor on. All right, I'll waive the cost of the monitor. Sir, the court is very concerned about the safety of Giselle Perez Campo. The court will order you have no contact with her directly or indirectly. Stay 500 feet from her at all times. You'll have an ankle monitor on. I'll waive the cost of that monitor. You're not allowed to possess any guns or weapons, firearms or ammunition while you're out. Said Miss Campo, I'm going to read this into the record, was complaining of stomach pain and was holding the right side of her forehead. She was favoring the right side of her stomach. Observed the right side of her face, forehead to be swollen, show signs of redness. She advised that her boyfriend punched her several times after an argument. She was scared of him. She even said, quote, "He will kill me if he finds out I'm talking to you." When asked if there's been past domestic issues, she stated each time it gets worse. She had a black eye. She had black eyes, plural, from being punched in the face by her boyfriend. Afraid of reporting to the police for fear of being deported. She says that she's in fear, allegedly hit her with closed fist, open hands. She's afraid that he's going to kill her. She said he becomes violent when he drinks. So the court notes the level of violence, the history of violence, and The court notes that he does have a very long history. He's been declared a habitual offender in the past. He's gone to prison at least 3 times. The court can see multiple burglaries, petty thefts. So the court today is going to set your bond on count 1 at $25,000, count 2 at $5,000. Your bond's $30,000. As I said, plus pretrial release with a GPS monitor. Waive the cost. Thank you. Okay. May I see Angelise Marin, Amanda Clark, and Amelia Clark. Ma'am, do you think you could make another attempt at contact the alleged victim on Stephen? Word on. What?
Yeah.
Okay.
Yeah, when you don't have to,
Okay. Okay, Angelise Marin. Where's Miss Marin? By the way, Miss Clark, the Clarks have both bonded out. They'll be out of jail. They don't need to come forward. Okay, now, Miss Marin, possession of cannabis, count 1, and count 2 is a probation violation. Let me look here. Okay, ma'am, count 1's 102, no bond. Thank you. Let's see, Isis Corley. Was she in here again? Oh, Isis Corley.
Your Honor, Paul Ryan, she refused. She's not feeling well.
She refused? Okay.
Yes, sir.
I'm going to set her bond at $300 on count 1, $1,000 on count 2, based on what the court knows her lengthy criminal record. How about Gerardo Guillen, Hanor Demiracle, Stephen Caro, and Don Chappelle?
Gillian bonded, Judge. Hanner, come on up.
Guillen. How about Hanor Demiracle?
He's present at the main, Judge.
Did you skip the 2 females?
No, they bonded Clark.
Okay.
They both bonded.
Okay, just want to make sure.
All right. Sir, do you still live on 3rd Street in Pompano?
No, sir.
Where are you living now?
I stay at Esquire Lakes, 10 Court.
You where? What?
Esquire Lakes, 10 Court.
Who lives on 3rd Street in Pompano?
We used to stay there.
Do you have any family members there now?
No, sir.
Okay, here's what I'm going to do. I'm going to release you on your own recognizance. However, you're going to have to go to the clerk of the court at one of the courthouses in the next few days and change your address, all right? Or you're going to get a warrant out for your arrest, all right?
All right, sir.
All right, there you go. Thank you.
How about Stephen Caro? Got it. Caro's bond has been posted.
Yep.
Probable cause found. How about Don Chappelle? Isn't he? No?
No, that's Steve.
Oh, you're right. Sorry. All right, where's Don Chappelle?
Don Chappelle.
Don, wakey, wakey.
Only in the jail would you hear that, you know? Only in the jail.
Actually, I say that all the time.
That could have been the first time anybody's ever said that in a jail or prison facility. Wakey, wakey. All right. Possession of PVP and a municipal ordinance violation. Court finds probable cause. Are there any priors on this gentleman?
No.
And
Assault with a deadly weapon and battery, 2009. Possession of cocaine, drug paraphernalia, 2004. Possession of cocaine, 2001. Trespass, 2001.
Got it, sir. Sir, do you have any money in the bank?
No.
Do you have any ability to bond?
Is Sark in there?
No, I don't.
Sir, just based on your criminal record, I'm going to go ahead and say you bond at $1,000. Thank you.
Yeah.
How about
Good luck. Down the middle, out the
Devon
door.
Whitehead, Emron Gould Sharon, and Jeffrey Bjorkman. I think somebody
Whitehead.
bonded here. Hold on. I think I got a message. Somebody bonded. Give me a moment.
More here, Magistrate Court. We're going to need to leave. Okay, thanks. Bye.
What's his name?
Jeffrey Bjorkman.
Are you Devon Whitehead?
No, I'm Jeffrey Bjorkman.
Whitehead, judge showing ROR.
Is it? ROR? Okay, you're right. ROR on Whitehead.
Yep.
Bull
You're
Sharon
Bull
bond has been posted.
I'm Bjorkman.
He declined the services as a public defender.
Okay, who's this gentleman? Bjorkman?
Yes.
Okay, sir, just give me a moment here.
Slide down, guys, on both roads. Slide down, you guys move up to the front. You see guys on the back there, I'm up here on the front row.
Okay, Mr. Bjorkman, possession of PVP, tampering with evidence, court finds probable cause. Do we have any priors on Mr. Bjorkman? Okay.
We'll just argue, Judge, no PC for count 2.
Has there any
Much that?
in addition to that, have there been threats of violence in the past?
When I approached the window, Bjorkman attempted to crush the foil and destroy the narcotics contained in the foil.
You know,
That's kind of conclusory. Judge, whatever he did, he didn't throw it away. He didn't try to hide it. He just folded it up. It doesn't sound like he really destroyed evidence or tampered with it at all. It's all still there. Still enough to charge him with.
Well, that's not the, I don't think that's the standard or requirement for tampering with evidence, whether there's enough to charge him with. I think that, hold on. Oh, wait. Hold on.
I think I have enough.
Tampering with evidence. No person knowing that a criminal trial or proceeding or an investigation by a duly constituted prosecuting authority, law enforcement agency, grand jury, or legislative committee of this state
Yeah.
is pending or is about to be instituted shall alter, destroy, conceal, remove. So I think under the alter, I think that's enough. All right.
Judge, by crunching it up, he did not materially alter the evidence. Furthermore, there was no, at the time that he did it, he was not aware that there was any investigation going on. He had not yet been contacted by police.
Mr. Miller, I think that's a great argument. You will make it trial. And if the jury believes you, then more power to you. But today, the court's going to find probable cause. State?
Yes, Judge. He is currently out on bond for possession of cocaine and drug paraphernalia.
What's the case number, sir?
The case number is 147563 CF10A.
Got it. Okay, sir, today the court's going to set your bond at $2,000 total, revoke your bond on 147563 CF10. You're going to be held without bond. Thank you.
Thank you, Judge.
You want me to get the you
now.
want me to get the MOs out of here? Yes. Okay. Do you have a copy of those? Did I hand them to you?
Yes, we do. We have them right here, Judge.
Okay.
Happy to return them. Mr. Christopher Lyons is
Okay. Bessie Christopher Lyons.
two sleeping on the beach, one in a new case and one a capias.
Judge, I'm sorry. If I could recall,
I've been trying to get in. I got some people that help me on the streets to try to get me in a rehab.
Christopher Lyons, please.
Judge, if I could recall Mr. Borkman, we just need a SAP order for
Sure,
him.
I'll order that.
Thanks.
There you go. What about Christopher Lyons? So you're here for 2 counts of sleeping on the beach. Hold on. There's another Fort Lauderdale case, I believe.
No one ever wakes me up. No one ever gives me anything. We're not going to wake you up, sir.
Okay. Lyons, would you like to resolve your cases today, sleeping on the beach?
Yeah, sure.
Okay. He does. What's the third one?
She has an open container. It's case number 154255 MO10A.
What's your name? Chris
He
Lyons.
has not been
Thanks.
arraigned. The arraignment date on that case is set for May 4th in front of Marty Cone. Judge Marty Cone.
What do you suggest we do? Resolve them?
I would offer him a global plea to resolve them all today, just as you were about to do, Your Honor.
Right.
I would just let you know that it's 3 instead of 2. He hasn't been around that much. His history's rather slight. He has a 2009 St. John's adjudication for trespass, and he has a, that's it, in our case.
Sir, how long have you been in Broward County?
Since January?
Okay, and what was the reason you came here to Broward County? I see you're from Oregon. What'd you come down here for?
The sun.
Okay. Any
Hang out
reason you came to Fort Lauderdale versus going to Orlando or Tampa or, Fort Lauderdale?
No, I mean, I guess I heard, I was just vacationing. I've been here since, a few months.
Did you hear something about Fort Lauderdale?
Mm-hmm.
What'd you hear?
It's a good place.
Good place for what?
Yeah. Come on vacation.
Okay. All right. That's what I think I know. I think I know. All right. Well, now. Okay. Give me the case number on the other one again.
Yes, Your Honor. The one that's not in front of you right now is an open container, and it's case number 154255 MO10A. And again, Judge, it's open container, and it's being arraigned on May 4th, 2015, in front of Marty Cone. So if he wants to waive his arraignment, and it's already filed.
Okay, sir. Here's the thing. If you want to work out, what was he charged with on that open container?
That's an open container, Your Honor.
I don't remember getting that ticket.
Okay. Well, look. Here's the thing. You're here for 2 sleeping on the beaches, 1 open container. You want to resolve all of them. You get out of jail today. The cases are all wrapped up. If you want to do that, all you have to do is plead no contest to all 3, and then you're not going to have a trial. You're not going to have your day in court on these. It's wrapped up. Is that what you want to do?
Yeah.
How do you plead to all 3? I wrote the case.
No contest.
Okay. Sir, I'll accept that or withhold adjudication on each and every count, all right?
Okay, thank you, sir.
All right, let's go to the next one. All right. Now, may I see Atkinson Timothy? Atkinson Timothy. Where are you, sir? Timothy? Is he there?
Not here.
No. Count 1 is 102, 500. Count 3. I'm going to, you know what? I'm going to point you on count 3, all right?
Which guy? Timothy Atkinson. I don't have him.
Have Atkinson Timothy.
He's on page 15 of the morning docket.
May not be Fort Lauderdale, Your Honor.
You're right. Okay, so I'm gonna release him ROR on count 3, all right? There you go. I think we have other Fort Lauderdale cases.
We do, Judge. Can I?
Oh, you do?
Yes.
Michael Fitta.
Yes.
Michael Fitta.
In jail. There he is.
Here I am.
Hey, Mr. Fitta, how you doing?
Good, John. How are you doing?
I'm doing all right.
Like I
Mr.
said-
Fitta, are you working now?
I am not.
Do you have any money in the bank?
I do not.
Do you want me to appoint an attorney to represent you?
No, but I said earlier we resolved this 3 weeks ago. It's the same trespassing. Same one, the only one I had.
Right. Sir, you've been trespassed so many times. You've been arrested so many times, Mr. Fitta. And I like you, but since I've been a judge, you've been arrested so many times, there's no way I can keep track of it. It's the same thing.
I understand that.
So, I have an attorney, a special public defender here I'm gonna appoint to represent you, all right? So I'm gonna appoint Mr. F.J. McLawrence, all right?
Thank you, Judge.
Thank you. Here you go.
What would that be?
$250, thank you.
Yeah, grab one of those cards that's under the podium.
How about Thomas Ritter, come on up. Count one's Fort Lauderdale, count two's down in, hey, Mr. Ritter. Alcoholic beverage violations in Fort Lauderdale and down in Hollywood. You want to resolve them both today?
Yes, sir.
Do you need me to give you an attorney to make this decision, or can you go without an attorney?
I could go without a
How do you plead?
attorney, Your Honor.
Okay, how do you plead on
No
this? I'll withhold
no
adjudication
contest.
on each one. Thank you. How about John Toledo? Toledo, you're here for
Yes.
open container of alcohol. You want to resolve it right now? We have one more for Fort Lauderdale. You want to?
Tell me right now.
You want to plead no contest?
No contest.
All right, sir. How long have you? Do you need an attorney to help you make this decision, or can you go without one?
I don't have background, Mr. Toledo.
I don't have an attorney.
Andy Laney is Hollywood.
Okay.
You're asking, do you want an attorney or do you want to plead? I want to plead no contest.
Do you need me to give you an attorney to help you make this decision?
Yes, sir.
You need an attorney right now?
Yes, sir. I need it. Yes.
Oh, let me back up. If you want to plead no contest, the case is over with today and you're out of jail today. Now,
Yes, sir.
do you need me to have you sit down with an attorney and go over this, or can you plead
No,
no
sir.
contest without an attorney?
No, sir. No contest. I don't need an attorney. No
Okay.
contest.
So you plead no contest. I'm going to withhold. Well, hold on. I want to just do something real quick here. No, no, I don't need shade. You're here. So, State, could you run his BCCN? I want to make sure he's not
Absolutely.
a registered offender.
Well,
Could you find that out?
I can tell you if he's had anything in Broward.
765313. 765313.
He's, from what I see in my system, he's not registered.
Okay, sir. You plead no contest. Am I correct?
Yes, sir.
I'll withhold adjudication. Thank you. Louis Jones?
Yes, sir. That's it. You're done. I'm going home. You're going home.
Louis Jones, sir, you're here for a controlled substance. You want to work this out today, Louis? Plead no contest.
Yes,
Case is
sir.
over?
Yes, sir.
Do you need me to give you an attorney to help you get through this?
No, sir.
How do you plead?
No contest.
I'll withhold adjudication. Good luck, Mr. Jones. Thank you.
Okay, thank you.
I'll tell you one thing. All right.
He's
yeah,
on
he's
loan.
sick. Medical. Set for tomorrow.
He's reset for tomorrow?
Yep. Jamie Stewart, Aim Ham, and Breon Perry. Thank you. Excuse me? Okay. Bonded. Okay. Aim Ham. Mr. Ham, just bend down for a moment. There you go. Just want to see your face. All right. Thank you, Mr. Ham.
Judge, real quick, on Mr. Pollard.
Yeah.
He's going to be saying for the police request for marijuana.
Judge.
What? Oh, yeah. I'll release him ROR.
Thank you, Your Honor.
Yeah. Do you want to give me an order for that?
You've
or
got a
somebody?
court date on Tuesday. You're going to see the judge on Tuesday.
Give me an order. Release him ROR. Excuse me? 6-6. It says on here. Yeah. All right. 2 counts of violating community control, Mr. Ham. Thank you. No, are you here on the?
Breon Perry. Perry, come on.
Wait.
Okay, Breon Perry.
Right here.
Sir, you've been charged with violating probation. That's a no bond hold. Thank you, sir.
All right.
Stephen Ruiz? Stephen?
There's a case that didn't make the guys at Conte, Rufino Bailey. Rufino Bailey.
I bonded.
Didn't do that before?
No, I don't think we did. It's a reset for today. For this
I've got it right here.
Oh, yeah.
Rufino Bailey, where are you, sir?
Over, they want to.
Hello, Judge Conti. I'm in Conti. I'm
Sir,
here today.
count 5 and 6 are additional charges on you.
Yeah, but 5, that's impossible that it could be me. I was only 16 years old. That's not me at all. Yeah, Judge, that's the one that the clerk. The 6th charge I got.
Odyssey hold on, Mr. Bailey. Mr. Bailey, hold on. Go ahead, Mr.
Odyssey assigned that case number to another person, a female actually. I have it in the other docket if you want me to get it.
No, I believe you. I believe you. So, you're telling me that count 5 and 6 you've checked and they're assigned to somebody else?
Judge, I told you count 5 is assigned to somebody else.
Okay.
I don't know about
Steve,
count
I'm
6.
gonna
I don't even know, frankly, Judge, the only paperwork I had was for count 6, so I don't even know anything.
Okay, so I'm going to release an ROR on 5, count 6. Your bond's $500, sir, on a
Hold
misdemeanor.
on, sir, can you hear me? Count 6, you told me you're going to release me on RR. That's the driving with suspended license. I got it. Yeah, count 5, that's not me. The 5th one is quick question.
Well, I got a couple other things, but.
It's March 26. Hold on. Yep, you're right. I'm going to release your ROR on 6 also. Thank you.
All right, thank you very much. Have a great day.
Okay, now, let's go with, Steve, you ready to go on yours?
Yes, Your Honor.
Okay. Now, may I see Stephen DeGurdon?
He's present at the main judge?
Stephen DeGurdon, sir, we have 2 attorneys on your behalf here in the courtroom with me. Mr. Greitzer and Ms. Kaplan. Good afternoon, both of you.
Good afternoon, Your Honor. Howard Greitzer on behalf of the defendant.
And Connie Kaplan on behalf of Stephen Beverton, Judge?
Yes. Okay. The defendant, before I knew that he was going to hire an attorney, I was able to garner some information from him. I know where he's employed, and I think I even asked him if he was prior military, and he said no. Those are kind of standard questions I ask. And then, other than that, I don't think I got much further. So, I was charged with domestic battery, and.
There was, you know what? I almost forgot. Can we approach? There's one thing I forgot to mention
Okay,
before.
come on up real quick. Excuse me. Okay, now, excuse me, we had a moment there where we discussed something. Your attorney and the state were present for the discussion. Now, do you have any comment about probable cause regarding the battery?
Judge, for purposes of the bond, we would stipulate solely for purposes of the bond as to probable cause.
Okay, what we have is there was a argument where allegedly the defendant became angered, punched a hole in the kitchen wall, allegedly grabbed a crowbar, and allegedly used the crowbar to deflate air out of the two tires of, I'm not sure whose car, but a vehicle in the driveway to her vehicle. And then they allegedly got in some argument at her in the car, and allegedly he grabbed his wife by the arm, and it says violently pulled her out of the vehicle. And it says that they've been married for 5 years, have one child in common. So.
And Judge, just solely for purposes of the record, the facts as contained in that probable cause, we're not at this point arguing for probable cause purposes. We're taking what the officer said solely for purposes of this hearing as being truthful without the benefit of having done any independent investigation, nor having interviewed the defendant as to the facts.
Court understands. Okay. Let me ask State, you told me earlier there was a prior battery that he received a withheld adjudication he wasn't convicted on, is that correct?
No, he received a withhold, Your Honor.
Received a withheld on a battery. Was it a domestic battery?
No, Your Honor.
It was a misdemeanor battery.
Yes, Your Honor.
Okay, and did he have a term of probation?
There was, I believe, 6-month term of probation.
Do you know when that was completed?
If I can check Odyssey, it's there.
Go ahead, Ms.
About 2 years ago.
It was completed about 2 years ago, the probation. Was it successful completion of probation? All right.
I can tell you that, Judge. He was sent, from what I saw, he was sentenced to 6 months probation, and it was terminated.
Okay. Now, do you have any comment about bond or release conditions at this time, State?
Your Honor, I did have an opportunity to speak to the alleged victim. She informed me she does have some safety concerns there. She informed me there has been prior incidents. So, Your Honor, I would be asking at this point, Your Honor, I would be requesting a $7,500 bond and no contact. I did speak with counsel already because it does mention a child, Your Honor, and I spoke with the alleged victim. We have no objection to third-party contact with, I believe, the alleged victim's aunt and uncle regarding seeing the child. She did inform me that she does not want to prohibit him from being able to see his child.
Okay.
Judge, if I might.
Go ahead.
As to the defendant's position regarding bond, I'd ask the court to set a $1,000 bond. It is anticipated that he will likely, as a result of this arrest, pending further investigation, be suspended without pay, potentially for some period of time, that the economic situation would warrant it. He's been in this community for a significant period of time. He does have a child that's still here with whom he has had regular contact. And as such, I would ask the court to consider a pretrial release as an option.
The court today will set the defendant's bond at $5,000. The court notes the level of violence, the grabbing of the arm, in the surrounding alleged violence, punching the hole in the wall. The court does note he does have a prior battery he was not convicted of, but he did have probation for that. The court notes that the alleged victim says there are some concerns about his temper, I believe. Is that what she said?
Yes, Your Honor. She expressed to me that she believes there are anger issues.
The court will order that contact with SD, that's Sierra Delta, is limited to indirect contact only, and that is only regarding the child. Apparently, SD believes that the child is safe in your custody, so you can contact a third party, probably a family member.
Your Honor, we would specifically request that it be through her aunt and uncle, who I've been informed he knows them, he knows how to contact them.
Through your wife's aunt and uncle, you can go through them regarding the child. For the time being, sir, you must stay 500 feet away from SD, that is where she lives, works, goes to school, anywhere in between. And, sir, you are not allowed, pursuant to paragraph 3, you are not allowed to purchase, possess, or carry any firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition. You must surrender any permit you have to possess any weapon or maintain any weapon. And You're not allowed, under any circumstance regarding any license you have to any exceptions to this order, unless there's a future order of the court which vacates this court's order. Is there anything else we need to do?
Nothing from the state, Judge.
Nothing from the defense, Your Honor.
Okay, thank you.
Thank you, Your Honor.
Sir. Okay.
Have a seat right there.
Absolutely.
May I see Vincent Scavo?
Judge, one moment, please.
Let me call him.
Judge, I had an opportunity to review the probable cause affidavit and the reports provided by the police, by the state in this case. I guess I should wait until Mr. Linder makes his argument, and then I'll make mine.
Go ahead. Mr. Linder, you're seeking to
Yes.
foreclose bond and release conditions?
Yes, Your Honor. And I want to first, Your Honor, I would base my argument on, and I know you've already had a first appearance for his brother, and Your Honor, upon reviewing the reports, I believe Vincent Scavo and Vito Scavo are in two completely different positions, Your Honor. Vito Scavo was more almost acting, it appears, as backup to Vincent Scavo, whereas Vincent Scavo, by his own admission, confronted the victim when he was standing in his own home, by his own admission. Yes, he had a knife, but you can carry a knife in your home. He entered his home, took the knife away from him, at which point he armed himself by his own admission, struggled with him in his own home, by his own admission. And, Your Honor, I would, since this was brought up this morning, I would like to bring some, because I spoke with the prosecutor handling this case.
Okay.
Judge Robinson never had an Arthur hearing on Vito Scavo's case. What happened was the state filed a charge and a capias was issued. Mr. Scavo's attorney had him surrender in front of Judge Robinson. Judge Robinson said, well, okay, I understand Judge Hurley ROR'd him at his first appearance, so I'm not even going to have an Arthur hearing. I'm just going to order him ROR'd. So there was never even a hearing to determine whether there was proof evident or presumption grade or not. So, Your Honor, I believe based on, and I understand the ruling Your Honor made, but certainly more information, more reports have been provided to you than you had the ability to consider at that time, Your Honor.
I understand. Mr. Miller, go ahead.
Okay, Judge, first of all, I would like to point out, if the court will please refer to the case supplement report authored by Tonelli, and that's page 1 of 3.
Let me find it. Hold on.
He's fighting you right now, Sarge. I'm aware.
Yeah, got that.
Okay, so if you look at the first line of that report, you'll see
page,
that on
which page?
page 1.
Got it.
Okay, on February 5th, 2015, defendant Vito Scavo reported to Hollywood Police Department, proceeded to make a statement, and then proceeded to, if you look on page 2 of that, the first, the last line of the paragraph at the top, Scavo, that's Vito Scavo, indicated his brother, that's Vincent Scavo, that's this gentleman standing next to me now, was not present during the fight. Then he goes on to say that the initial interview, Vito, the other guy, indicated that there was an altercation between the three of them. I'm going to argue to the court that that's not, that Vincent not being present at the fight is not exclusive of them having an altercation. An altercation can be a verbal exchange. So they could have had an altercation. They actually worked together. So that's not mutually exclusive. So you've got Vito, okay, who's the one who made the statement, not Vincent. Vincent never has made a statement in this case. And he did not make any admissions in this case. He's never been interviewed. He's never given a statement. It's Vito, the person that you ROR'd back in February, who made this statement to the police. Okay, so we have Vito, who is exonerating Vincent, saying he wasn't even there when the fight took place. Okay, even though they may have had an altercation. Now, I would like to, with the court's permission, read into the record by way, in order to refresh recollection. I wrote this memo, an email to my colleague who had magistrate court the weekend following Vito's magistrate court, and I wanted to apprise him of the situation, and I wrote this. Scavo's employer, Joseph Caristo, testified at magistrate that Stephen Walker, that's the alleged victim, posted a selfie showing his injuries at 3:44 a.m. on February 4th, and that he, Walker, texted him, Caristo, that's the owner of the business who testified, at 6:33 a.m. This contradicts his statement to the Hollywood Police Department that the attack occurred, quote, at or about 03:30 hours, end quote, and that, quote, he remained unconscious on the floor until he contacted police at or about 08:37 hours. Next paragraph, Walker also advised the police, quote, he advised the owner, Caristo, of Joe's Old School Pizza, Joseph Caristo, that he observed fellow employee Vincent Scavo smoking cocaine at work, and that, quote, he was fired by Caristo a short time after he had this conversation with the owner. And if you'll recall, Mr. Caristo testified at magistrate that Walker made the allegation against Scavo after he was fired, not before. And that was the testimony of the owner of the business. And this is the last paragraph, Judge. The state attorney did not seek to foreclose bond. Judge Hurley found probable cause, but also found Caristo's testimony was an obvious, objective contradiction to allegations by Walker, and that, quote, this is you now, I'm quoting, it appears that the alleged victim fudged the facts in the case. He released Vito Scavo on his own recognizance. So we have a situation where Vito Scavo testified appeared before the court. The court released him. The state did not seek to foreclose bond. Okay, he admits to the police that he had a fight with the alleged victim, and says that this guy wasn't even there. Okay, now the state is saying that he's in a worse position than the person who's admitting that he had a fight, and that doesn't make any sense. And then in that case, the state didn't even seek the foreclosed bond conditions.
Okay.
Judge,
I think you.
and as far
Okay. I think you've made a very strong argument. State, go ahead. What's your position?
Your Honor, I made the argument. I have no additional legal argument this time.
We released on your own recognizance.
Wait.
I find probable cause.
Wait, Your Honor.
Thank you, Judge.
Your Honor, wait.
What?
You gave his brother an ROR because he had no criminal record.
Right.
He's not in the same position.
Okay.
You're not going to consider his criminal.
I'm going to do this. I'm going to find probable cause. I'm not going to find proof evident presumption. Great. Go ahead.
Thank you. Your Honor, he just got off probation February this year in Dade County for fleeing and eluding law enforcement. One moment, Your Honor.
In any event, sir, you're not allowed to have any contact directly or indirectly with, Stephen Walker.
Okay. Additionally.
No contact. Stay away from him.
Pennsylvania. Well, I'm sorry, one moment. Out of New York, Your Honors, priors include criminal possession of stolen property, 2013. 2012, criminal contempt in the first degree, violating an order of protection, making physical contact. 2011, criminal mischief in the third degree, damaging another person's personal property. Criminal contempt in the second degree, disobeying a court order. 2011, harassment in the second degree. Criminal obstruction. Reckless driving, 2001.
Sir, I'm going to give you a bond of $1,000. Thank you, based on your criminal record and facts of the case. Thank you.
Thank you, Judge. Appreciate it. How'd you go?
Let me call my brother.
I will. I'll call him.
Okay, Stephen Ruiz, Brandon Tyson, Devontae Atwell.
Judge, Mr. Ruiz is present at the main. He has indicated that he's going to decline our. He believes that his bond has been posted. He also asked if the court could reset this to tomorrow so that he could have an attorney present.
I'll reset this for Friday p.m. I'm going to find probable cause. Your bond's going to be the $14,500 until then. Reset for Friday p.m. Thank you. How about Brandon Tyson?
Good luck. It's already posted. Mr. Tyson's a medical reset, Judge.
I'm going to just pass it through, no bond. It's going to the division. Devontae Atwell.
This is Mr. Atwell, Judge.
Sir,
Yes,
property loss
sir.
is found on violating community control. They're all no bond. Thank you. Oh, boy. Now see, Newton Smith.
Go back here.
Newton Smith, please come forward.
Judge, he is meeting with his attorney at this moment.
What?
Okay. Okay, now, who do you have over there, Mr. Miller?
Antonio Hernandez, Judge. He's a reset from this morning.
It was supposed to be perfection, but frankly, Your Honor, if you want to you had mentioned this morning, Your Honor, that
You were going to ROR me on both counts this morning.
Right, and then you gave the state 24 hours to perfect. I think he just got.
I thought we were resetting it for tomorrow.
Yeah, but Your Honor, while he's here, I mean, the issue was, I understand.
What was the issue?
Your Honor, I'd asked you for clarification because I mentioned an argument from the report. You had mentioned, oh, I hadn't read that. And so while he's here, I'd ask if the court could take note of what's alleged there. That, as I stated, your concern was that there wasn't evidence connecting any criminal activity to the burglary tools. What I had argued to Your Honor was, first, this stemmed from an anonymous call that a person was observed using tools to try to steal an air conditioning unit. They get to the scene where it was alleged. They find the defendant with burglary tools that would appear to match up with cutting the wire of, and they mentioned they find an AC unit where the wire's cut. There's a clamp mark, which would also seem to match the tools that were found in him. I think there is probable cause. I'm not arguing the loitering and prowling because of what he was doing necessarily when the police got there. I'm arguing that based on the totality of the circumstances, when they fully investigated the situation, I do believe there's grounds for possession of burglary tools.
Do we know who this anonymous tipster is?
They do. And the reason I know that is I spoke to him.
You spoke to the tipster.
I spoke to him. He gave me his name. As an officer of the court, I can tell you I spoke to him. It was a mistake. I didn't intend to, but he called me.
So you would know his name if you had to get back in touch with him? Do you know how to get in touch with him?
Got his number right here.
Okay. Sir, here's what I'm going to do. I'm going to find probable cause on the burglary tools. Count 2, I'm going to find no probable cause.
Now, the other issue was, Your Honor, if I could have his BCCN number.
Right.
I believe he has a pending burglary.
Is it burglary, conveyance burglary?
I just want to, could you give me his BCCN number, Your Honor, please?
It's 630721.
Burglary of a structure and possession of cocaine. He also has a prior burglary structure from 2013 with the grand theft, dealing in stolen property, false ownership twice in 2010, dealing in stolen property 2010.
Those
Multiple
are all old
drug priors
charges.
in addition to
I got
that.
it. So what's the case number he's out on?
149163 CF10A.
Sir, today the court's going to find probable cause on count 1, bonds 1,000. Bond is revoked on 149167 CF10. You're going to be held without bond. Thank you.
Good luck. Sorry about that.
Can I have an order? We don't need to bring it back. We
No.
can bring it back tomorrow anyway.
Well, no, there's nothing left to do now.
Where's the paperwork, though?
Well, I'm at 438.
Yeah, have we ordered a Spanish interpreter yet?
I'm speaking. Boy, I tell you, it's been like a drag race in here today, you know?
Yes, sir. Like a
I mean,
snail's drag race.
Somebody just hit, floored it at about 8:30, and then that thing is just. When I get home, I'm gonna.
Is he on
Now, who do
So,
you have
Judge,
right
this
here?
is Christopher Johnson. He's on your second look docket. He is on a petty theft for $100,000. I'm sorry, $100 bond, and has been in custody since Sunday.
I tried to get out that day. I meant to plead no contest, but didn't understand exactly what was going on. So I wanted to talk to you before we even got up here.
Mr. Afsal, did we order the Spanish interpreter?
No, I'll call for one.
Would you please? We have Mr. Herrera.
No. I don't. Oh. Yeah, no, I got it.
I put PTR pending on this gentleman.
Who's this?
Were you able to get him out of here? This is Johnson. First name is Christopher.
See you tomorrow.
Do you have a phone number for a contact for a pretrial? We can provide one if you don't.
I mean, I stayed.
On the alternative is he can plead it out today.
Hold on one moment, Judge.
Oh, excuse me.
We would ask for 6 months to pay court costs, please. Judge?
Yes, sir.
We would ask, we'd like to plea and ask for 6 months to pay the court costs.
Sir, how do you plead to petty theft, Mr. Johnson?
No contest.
Do you understand we're not going to have a trial? You're not going to have your day in court. The case will be over with right now. Is that clear?
Yes, sir.
Okay. Sir, I'm going to, how do you plead?
No contest.
I'm going to withhold adjudication. I'll give you 6 months to pay the court costs, all right?
Thank you, Judge.
Thank you, Judge.
Who else do you have over there?
We have Betancourt on page 6. That's a MM, resisting without unlawful use of false name or identity, and I think he wants to try and plead this out if he can.
You have Betancourt?
Betancourt, yes, sir.
I don't have that paperwork.
It was a reset from this morning. I don't know why. I think because we were going to try and plead it out.
He would have gave me bond.
I gave, no. I gave him a bond.
Oh, that's right. You offered to plead out, and you gave him a bond instead. That's right.
There you go. I think his bond was.
So this was a mistake.
Thank you.
Bye-bye. We have McBride.
Well, let me ask you, do you have any more misdemeanors over there so I don't have to flip the computer?
No, I've got McBride, who's got an MO, and I've got Mr. Herrera, who's got a new felony.
Okay.
Mr. McBride's MO is from 2000.
I don't think I have it.
It's page 7, Judge. I don't see any paperwork on it.
So.
It's not a reset.
It'll roll tomorrow. We'll see you tomorrow, Mr.
Okay.
McBride. Thank you.
We'll see you in the morning.
Okay.
Who else do you have over there?
Actually, Judge, can we reset him for the afternoon and skip a step?
Yeah, we'll just do it to the afternoon on McBride. Go ahead. Who else do we have?
And Mr. Herrera is waiting for a Spanish interpreter, Judge.
Got it. Anyone else?
That's it.
Okay, thank you. Let me see. Where's Jefferson Ely or Ellie? Jefferson Ellie.
Conti, Your Honor.
Sir, you have a battery charge. I'm going to send this to your division judge. I'm not going to take any action on it today, all right? Thank you.
All right, sir.
Yes, sir. How about Chartman Roberts? Chartman Roberts.
Conti, Your Honor.
Mr. Roberts.
Yes, Conti, Your Honor.
He knows.
Could you hear me? Your Honor, can you hear me?
Mr. Roberts, would you like to plead your case out today?
Yes, sir.
Sir, you understand that if you plead no contest, the case will be over with today. There's not going to be a trial. Well, you're not going to have your day in court. It's just over with right now. Do you understand?
Yes, sir.
Okay, how do you plead, sir?
No contest.
I'll withhold adjudication. Thank you, sir.
Thank you, sir. Thank you, sir. Have a good day.
Let's suspend it. Do you want me to sign it? Here you go. Holy Pizzoli. Okay, now, how about Josu Cabrero? Josu Cabrero. State, is this a second look or is this a...
Just one moment here. I think they're both second looks. There's no 30 days.
Cabrero, where is Cabrero?
Did he bond?
Okay, we don't have Cabrero. He's got a burglary structure grand theft.
I'm showing he's being held at Maine.
He's got a prior burglary. I'm not gonna, not based on his criminal record, I'm just gonna pass it anyway, all right? So I'm gonna send it to the division on, okay, what about Monique Woodley? Do we have Monique Woodley there? Monique Woodley?
Yes, sir.
Hello, Judge. Good afternoon.
Hello, Miss Woodley.
How are you?
Fine, how are you doing, man?
I'm blessed but not stressed.
Okay. Miss Woodley, give me a quick moment, ma'am. You're here for cocaine. How come you've not bonded out of the jail yet, ma'am?
No one has the funds at the time. I have the funds, but no one has no way to get it to me,
Okay, I
sir.
understand. Ma'am, how long have you lived down here in South Florida?
Over 15 years, sir.
Were you working before you were arrested?
Huh?
Were you working? Were you employed?
I was attending school and I was doing a little, under the table work, just started working, so.
Right, I understand. You just take a look at this, ma'am.
Looks like she's out on a theft right now.
She's out on a theft?
Yes.
Yeah. But I thought they handled it in court when I went to Judge Michael Usan, but I guess they did not.
You got family down there, ma'am?
Yes, sir. I have family. My children are here. My family, my aunts, cousins, a lot of people down here. I have nowhere to. I have nothing but family in Florida.
Pre-trial release.
I'm still processing. I'm reading the report. I'll get it. I'll get to it. I'm gonna get there. Just gotta let me do my little thing. Okay, so looks like she's probably got a cocaine issue. Ma'am, I'm gonna release you today on your own recognizance. Tomorrow morning between 8 and noon time, you need to be in downtown Fort Lauderdale. You know where the main courthouse is?
Yes, sir.
Right across the street from there, you got to go to pretrial release tomorrow. They're going to give
Yes,
you a
I'll be
map
there.
right there, okay? Ask the man for a map, okay?
No problem.
Gonna
No
be there
problem.
tomorrow. Ma'am, you're going to be tested for cocaine and all kinds of drugs every week. If you fail a drug test, you go right back into custody, all right?
Yes, sir.
All right, ma'am, good luck. Thank you.
All right.
Sure.
Judge,
You know
that
what?
looks like a Spanish
Marge is
interpreter in there.
Marge is- so ask Carl. Carl, where can you photocopy something? Marge isn't there, and I don't know how to operate it. You know how to operate it? I mean, it's not a regular copy machine. It's some weird contraption.
Yeah, bigger guy.
That quick? Yeah. You're ready.
You want to try it? Look, if you want to go over there, give it a wing. Hey, yeah, I don't know how to use it, so.
They're right here.
Yeah, they're all, it is always withhold unless I tell you different. Yes. Yes. Okay, is this Mr.?
I know why you.
Oh, hold on. Mr. Herrera?
It is, Judge.
Make a note of it and put, no. No, not, no.
Okay, now, Herrera, ma'am, do I have the paper for Herrera? Ma'am, do you swear or affirm to translate from English to Spanish, Spanish, English truthfully and to the best of your ability?
I do. Alicia's taking over.
Okay, sir, you're charged with trafficking in cannabis
Señor, se le acusa de traficar en cannabis
and manufacturing, producing cannabis.
y fabricando o producir cannabis.
The court finds probable cause. Allegedly,
Pues
this
haya
man
motivo justificado.
maintained a grow house.
Alegadamente usted tenía una casa criando marihuana.
Okay, do you have any prayers on?
No, Judge.
Sir, how long have you lived in South Florida?
Señor, ¿cuánto tiempo lleva viviendo en el sur de la Florida?
Voy en junio para 8 años.
In June it'll be 8 years.
Do you have any money in the bank?
¿Tiene dinero en el banco?
No.
No.
Are you currently employed?
¿Está trabajando?
Hace 2 meses que no estoy trabajando.
It's been several months that I haven't been working.
Okay, do you have any means to bond out with? Do you have any
¿Tiene
family
dinero
members?
para pagar para fianza? ¿Tiene familia?
Sí, tengo toda mi familia aquí.
Yes, all my family is here.
Okay, sir, the court notes the amount of marijuana, 143 pounds worth.
Señor, el juez nota la cantidad de marihuana era 143 libras.
The court notes that you will be facing a minimum mandatory prison sentence.
El juez nota que usted va a estar encarando una sentencia obligatoria mínima.
The court notes you allegedly said you're the sole occupant of the grow house.
Usted dijo que era el único ocupante en la casa de criar marihuana.
The court will reduce your bond today, sir,
El juez va a rebajar su fianza hoy, señor,
to $35,000.
a $35,000.
Count two is 1,000. You can
El
bond
cargo
out.
número 2 es $1,000.
The bond is based on the amount and the weight of the marijuana and the strength of the case against you.
Su
Thank you.
fianza es basada en el peso de la marihuana y la fuerza del caso en su contra.
Thank you, sir.
Gracias, señor.
Merci.
Gracias.
Merci.
Judge?
Yes, sir.
We're clear at the main. Thank you. I'll see you tomorrow.
Thank you. Merci Newton Smith. Newton
He's still with
Smith.
his attorney?
What?
Last we heard, he was with his attorney over there.
Yeah, is Newton Smith over there in Maine? Maine jail? Do you have Newton Smith?
No, Judge, we're clear here. We don't have anybody.
You know what?
Didn't you already talk to him this morning?
Excuse me?
Oh, he was at an attorney interview, Judge. I guess we need to reset.
I'll set it for tomorrow PM, Tuesday PM, Friday PM.
Friday. Thank you, Judge.
Thank you. Okay, there you go. Okay, let me see. I'm just jumping around here trying to figure out what I'm doing. Okay, is there anything else we need to take care of?
I don't think so. I hope not.
Wow, what a
Please
day.
no.
Got it. Okay, everyone, thank you very much. And today is Thursday, so as I have always noticed, Friday comes right after Thursday, so tomorrow's the last day of the week, and
Hey, it's Eric.
we'll see everyone back here tomorrow,
Sorry,
last
man.
day of the week.
It's been a crazy day. So, yeah, but it's okay. What's up, man?
Okay.
Well, I'll look into it. If you want me to look into
Thank
it, I'll
you.
look into it. What's
So we'll
the
see
guy's
everyone
name?
back
Is
here
it-
tomorrow morning at 8:30. Thank you.
Well,
We're
is
out.
it